Counsel.
Yes, I can hear you.
Perfect. Now, while we await the details and also the full ruling of the justices of the Supreme Court on this matter by tomorrow midday, all things being equal, for the Attorney General, to the extent that this incident of cross-carpeting could happen again in the future, it was very necessary that the Supreme Court interprets and rules on Article 97(1) G and H to bring finality, so-called, to this matter. Is it one that you agree with?
Not exactly. You see, the circumstances under which this case went to the Supreme Court are different. And this particular case, it was so clear that these persons had cross-carpet. So the case would have gone to the High Court. So I don't particularly agree with him, except that, like I keep saying, because in law we have different schools of thought. They are using their own school and they belong to that school of thought. That's how come they will say it's good it went to the Supreme Court.
Hello?
The normal way, considering the fact of this case, would have been for it to go to the High Court under Article. If the High Court judge felt that they are not matter to the Supreme Court under Article 130 Clause 2. So the Attorney General is happy, but that shouldn't be right. We don't develop a democracy this way because these facts are clear. Look, today as we speak, Esiama is MPP. Today as we speak, Kojo Asante of the MPP filed to be independent, contrary to Article 39 of fails a candidate for parliamentary elections, and you also feel, you also file as an independent, you lose your seat automatically, right? So the same for Cynthia Mamle Morrison. Okay, so this thing is so clear, but you know, they ran to the court because they know that President Kufuor was careful in selecting Supreme Court judges for appointment, people who are like-minded. So they chose that forum so that quickly they'll get a decision in their favor.
I see. But the provisions of Article 97(1) G and H, from the understanding that I've got over the period that this matter has been traveling, are designed, Counsel, to safeguard the principles of party loyalty and some sort of political stability. So if this 97(1) G and H cannot check cross-carpeting, then which law can in our books?
Good. So what it is that the historical meaning being put on 97 G and H, yes, I appreciate it. But if that's all that it meant, the lawmaker or the framers of the Constitution would have stated so expressly. But where they haven't done so, this means if the framers of our Constitution meant it to just mean, oh, just crossing physically in the chamber from one side to the other, they would have stated so. But that's not the meaning at all. And if you go even to the what do you call it, the consultative assembly proceedings, as you see that they weren't limiting it to what some people are seeking to say, that it is only when you physically cross from one side of the chamber to the other side, that's from one party to the other, that's from majority to minority, or vice versa, that is when it applies. That's not true. If you read where the law was making them
And unfortunately, we have a jerky connection to Martin Kpebu, private legal practitioner there. But, you know, the Speaker of Parliament, Alban Sumana Kingsford Bagman, Right Honorable himself, has been also espousing a position on 1971 JNH, which was the subject matter of interpretation at the Supreme Court, which the Supreme Court has given a ruling, and the futuristic implication of the decisions taken by these persons, the four of them, in the eye of this storm. But Alexander Afenyo has also been talking after this, issued a statement, and it has a tone. Dennis.
Yes, so the majority leader has issued a statement, and it's in furtherance to the ruling by the Supreme Court. In that particular statement, he's calling for a truce. He's calling for cooperation from this other side of the House. That given that the Supreme Court has determined this matter, now they need to work together in the interest of Ghana for the people that they represent. But many have been asking questions that the tone of this letter is different from what we hear him say in his previous commentary, especially there was an instance where he actually accused the Speaker of conspiring with the NDC caucus in Parliament on certain matters. Let's take a listen to that particular sound clip.
Speaker is setting the country on fire. Yes. Yesterday, we were disappointed with his non-reconciliatory posture during this press conference. Indeed, we, the majority caucus, call on Mr. Speaker one more time to demonstrate statesmanship. Yes. We want Mr. Speaker to know that although we were not happy on the day he was elected, some of our colleagues perhaps has seen something good in him. It wasn't the NDC that put him there for him to do the bidding of the NDC. Perhaps people felt that he could be someone who will bring all of us together. Yes. There are things that we cannot say into the camera, but Mr. Speaker is hurting democracy. Yes. What Mr. Speaker is doing is to rehearse what the NDC is likely to do should they lose power, to bring chaos, to cause confusion. How can Mr. Speaker say that he respects the Constitution, but he will not subject himself to the dictates of the judiciary? How can you say that the judiciary is in collusion, is colliding with the president, and you mention the president as a person, as an individual? How?
Well, so that was prior to today.
Yes,
it had a certain connotation, and then there's
and even yesterday there was another sound clip where he had made comments to the effect that the MPP is bleeding under the Speaker. I mean, clearly that's when you put all of those things together and now contrast it with what we are seeing today by way of this statement. This certainly is with a softer tone and a more persuasive argument. I mean, sorry, statement, if you ask me. So parts of it reads that while we await the court's full written reasoning, its decision on this constitutional question is clear and binding. The Constitution does not grant the Speaker the power to declare parliamentary seats vacant. This is a restatement of what he thinks, his view on the law. Now he goes on to say that the Supreme Court's decision should not be seen as victory for one side or a defeat for another. Rather, it represents a triumph for our constitutional democracy and the rule of law. The ruling reinforces the principle that in our republic, every institution, no matter how exalted, must operate within the bounds of the Constitution. Now he begins to appeal to the various quarters. To my colleagues across the political divide, I extend the hand of friendship. The time has come for us to move beyond this episode and redirect our energies towards our primary duties. Duty serving the good people of Ghana who elected us to represent their interests. He extends another to the Right Honorable Speaker, that I reaffirm my utmost respect for your office and your distinguished service to our nation. Right. Emphasis, your distinguished service to our nation.
And this statement came in just a few hours ago?
Just this afternoon. This judicial interpretation of our Constitution should strengthen, not weaken, the relationship between leadership and members of the House. This is very, very important.
And the first part of what is on the screen there, you say his utmost respect for the office of the Speaker, and the distinguished service of Speaker Bagwin to the nation. That's a clear departure from what we've heard from. But then again,
when you put the two side by side, but when we progress on this conversation, you begin to understand why this is very necessary, especially when we put the numbers on the table and what is likely to happen in Parliament in the coming days.
Well, too late, better late than never. Professor Ransford Jampo is a professor of political science at the University of Ghana, Legon. Professor Jampo, you've seen this statement from the majority leader, Alexander Afenyo Markin. It sounds clearly one that is reconciliatory, at least based on what we have seen in that statement. Is it one that it would make a significant difference as things turn out now?
Yeah, the point is, if he knows how to sound reconciliatory, he should have sounded this right from the word go before going to Parliament. He should have gone to caucus with his colleagues to let them know. You see, it is today that you are in power. Tomorrow, if you go out of power, it is shame. And at the end of the day, it is our democracy that will suffer. And so my view is that the matter has not been resolved yet, because I can anticipate and foresee some NDC members of Parliament also saying that, well, in that case, they will also not be part of Parliament to give the needed quorum for important decisions to be taken for government business to run. And all these things do not augur well for our democracy. And so I am thinking that if there are elderly men and women in the Ghanaian society, let them rise up and let them intervene, and let's see how we can address this matter. Otherwise, look, the matter has not been resolved at all.
You said the matter has not been resolved at all. Dr. Rashid Draman, Executive Director of the Africa Center for Parliament.